Bond scam happened in February 2015. Newsfirst reported on the matter during the first week of March in the same year. To be exact, the 8th of March 2015 was the day we reported on the bond scam. When we reported on it, no one here or the people in our country did not know the severity of the bond scam. Day by day, when we revealed information, everyone understood the severity and the extent to which the bond scam has affected the country and our economy. To understand that topic really well, we had to sought the help of experts in the financial sector and even in the legal sector. We spoke to them and we asked them what this bond scam was and how it is a problem to the country. We have come to a situation where we have to once again seek the advice and the support of the experts when we are talking about the Foreign Exchange Act number 12 of 2017. This is the new Foreign Exchange Act certified on the 12th of July 2017. The regulations pertaining to this act came into effect on the 17th of November this year. We revealed the severity of the bond scam one day by day, and then the Presidential Commission of Inquiry was also appointed, and more details pertaining to the bond scam came out there as well. Now, as I told you, the date certified, this act has been certified on the 28th of July 2017. There are 46 members in the cabinet, including the President and the Prime Minister. This piece of legislation has to go as a draft before the cabinet and it has to receive the approval of the cabinet. Then this draft can be challenged by anyone at the Supreme Court and to check whether this draft or this piece of legislation is in accordance with the constitution of our country. Then there's of course the Parliament with 225 members. This has to then come to the legislature where this type of laws are put into the system, and then this becomes the law after the Speaker puts his signature on it. If this act has points in it that are severe, that are problematic, why did this not go through each of these stages at the cabinet? Why wasn't it pointed out? Why didn't anyone take it to the Supreme Court? Why didn't the parliamentarians, the 225 parliamentarians who discussed this matter, not know what was in the act if this is this problematic? Now, several mistakes, wrongdoings identified in the previous act, the Exchange Control Act that was before this act, have now been turned into acts of civic value. They do not entail any criminal charges. Once again, another point that is important is that according to this Foreign Exchange Act, the minister in charge of the central bank of our country is the minister in charge of foreign exchange. Currently, the minister in charge of the central bank is the Prime Minister of our country, Honorable Ranil Wickremesinghe. Several people expressed their concerns over the Foreign Exchange Act over the days, and this is the leader of the Janata Vimukti Peramuna, the JVP, Anura Kumara Disanayaka.
Ravi Karunanayake is facing an allegation on fraud that surrounds foreign exchange. This case was brought forward during the previous administration. We are aware there were certain agreements that were reached. I state this with responsibility. That forced the continuous postponement of this case. It transpired that former Minister Ravi Karunanayake had acted in violation of the regulations of the Ministry of Finance. That is the case. However, what happened in the end? The person who acted in violation of the regulations of the Ministry of Finance was appointed at the Ministry of Finance. After that, Ravi Karunanayake becomes the defendant. An official from the Ministry of Finance presents facts. The case clearly notes Ravi Karunanayake will be released and not acquitted. The Attorney General's Department says a case can be refiled. A case cannot be filed only if the person is released and acquitted. But he has not been acquitted of that charge. The case was rejected based on certain technicalities. However, there is provision to refile the case. But on the 25th of July 2017, an amendment is made to the Exchange Control Act, and that was presented by Ravi Karunanayake as the Finance Minister. He includes regulations where the wrongs that were committed were made right, and it affects the acts of the past. This act was produced and passed in Parliament to save oneself from a case filed against one.
Like the leader of the JVP, Anura Kumara Disanayaka, several other people also raised concern over this new Foreign Exchange Act number 12 of 2017. There were several stages that this act has to go through as a draft before it received the approval to become a part of the law of our land. Now, Did they not know what was inside this act when it was being discussed? The 46 members of the cabinet, the 225 members of parliament, did they not know what was included or the severity of this act before it came in to be a part of the law of our country and when it was a draft? Now, we remember there are previous examples set by various governments in our country. Best example would be the 19th Amendment, how they tried to discreetly put in statements that would regulate the media. When we as a media institution went before the Supreme Court ruled that if the government decides to put in regulations of this matter, there should be a public referendum to seek the public referendum and to make those changes. So there are examples where statements, clauses have been swept in discreetly for various purposes by various governments. So why did this act not go before the Supreme Court when it was a draft? Whatever said and done, there are mistakes, wrongdoings identified in the previous act, and according to this new act, these wrongdoings have to be looked into by these legal authorities and cases must be filed within 6 months. Is this practical with our legal system that is functioning in our country? With all the laws delays, 6 months, the time frame, is it enough to actually look into all the details, all the facts regarding a certain case and to file cases against this? However, the Foreign Exchange Act number 12 of 2017, certified on the 28th of July 2017, is now in effect, and all we can ask is the people and the people who are responsible, the Parliament or the Democratic Socialist Republic of Sri Lanka, to take the necessary action.
There's no issue at all because even the constitution can be repealed, and repealing is a very necessary provision of law. Because all laws need be repealed because you have to bring it contemporary and also relevant to the passing of time. With passing of time it must be made adjustable so that it keeps to the needs of society. So therefore this act can also be amended. And there's further proof, as I can see in section 30 of the Foreign Exchange Act, chapter 423 is in fact repealed by this act. 423 repeals it, and the words are very simple. All you have to say is such and such an act is repealed. It can be the whole act, part of the act, or certain provisions in the act. So you can safeguard the provisions and some of the provisions, but repeal the main act. And this is necessary because this particular act has absolutely weird provisions that are very detrimental and harmful to the economy of Sri Lanka. This is an act that can be called a hitman's act, an economic hitman act is this.